Okay, thank you everybody for joining us. It's 3 o'clock, so we'll kick off here. So we're in the final set of panels, so we appreciate you joining us. I just came out from the smart contracts panel. Just a quick show of hands, who here was at the previous smart contracts panel? Okay, so about half of you. So that covered some basics, but the title of this panel is Blockchain Governance and Security. So there's the governance piece of it, which goes beyond maybe the sort of transactional framework of smart contracts. But we'll do a little overview of blockchain. We've got an all-star panel here. We've got folks both from outside counsel perspectives, who obviously get a range of different perspectives advising various different companies in the space, both from the transactional and the regulatory side. And we've also got in-house counsel representative in Brindley. One of the really interesting things I found out earlier though was that on our 6-person best practices of in-house counsel panel, I'm not sure if any of you were there, 2 out of the 6 people who were representing were actually working at blockchain companies. And so if that says a little something about maybe the hype, or to the extent that we as technology lawyers, people at the intersection of law and technology, need to be aware of what's happening in this space, I think that maybe speaks somewhat to it. One thing that Sanam did say was she's here because she loves the intersection of technology and law. And I'm really here as a researcher, as an entrepreneur, and a lawyer, former practicing lawyer, as also someone who loves the intersection of technology and law. And I think that's, as a very meta, broad statement, why blockchain is so exciting. Here at Stanford Law School, we have a wonderful center called Codex that has for a long time been looking at the background of something called computational law. And we've been looking at computational contracts in the context of this broader field called computational law. And blockchain as an applied area of computational law is really something that we've been very excited about because of the additional interest from a lot of business people, a lot of engineers, who in many of your circumstances may have been coming to you saying, we've got this amazing new technology, we've got this amazing new business opportunity, let's do something. And you may be saying, whoa, what is this about? What are the risks? And so hopefully we'll give you a bit of that flavor today. This conference is very much about practical business-oriented focuses and dealing with emerging issues. And I think this is a classic example of where we have emerging issues where the state and international laws are somewhat in their nascency. They're unclear, they maybe impose different obligations. So we'll look at some of that, especially from the regulatory perspective. First off, it was touched on in that previous panel, this distinction between public versus private blockchains. I mean, again, we're interested in their use cases. So maybe if I could ask Brindley, from your perspective as an in-house counsel, and I also haven't done the introductions, so if folks wouldn't mind just saying a quick intro to themselves before they jump into their explanations.
Sure.
We've lined up a little bit of the expertise from each person, just to kick us off, but Brindley's going to give us this sort of larger overview of why blockchain is relevant as an in-house counsel, and maybe touch on that difference.
Maybe we just start with setting the table a little bit about what is a blockchain, and I have a way to describe it, and I think Andy in our prep, you had some ideas too, and other folks as well. So I think with all of these different perspectives, you can get a good sense of a starting place, and then from there we'll build into the various legal issues. So I'm Brindley. I don't have a name tag. I'm now at a very small startup of 30 people. I am now the only lawyer, and this is what happens when you're the only lawyer. Your name gets misspelled and you never even give your details to be put into the program. And here I am. So I'm now at a company called Cello. It's a blockchain company. It is building a platform very similar to Ethereum. And the idea is it's a full stack of technology, open source. And the idea is it will be available to developers from around the world to build financial products for their particular communities. So for example, if you are in an area that doesn't have a strong foundation in banking, or maybe you have a government that isn't necessarily trustworthy, and you have some basic skills, you can create a financial product, say in rural Tanzania, or in Argentina, or in Kenya. All the pieces are there for you to then spin up something that is workable, whether it's a lending type product, likely a regulated product, but a product that you can then work on with this technology. We'll talk more about that. Before I was at Cello, or working on Cello, I was at a company called Ripple, also a blockchain company. I was GC there for a couple of years, and then before that, PayPal and eBay, and then a law firm. So let's talk about what a blockchain is. I have a particular perspective from a cryptocurrency perspective because I think it's really easy to understand what it's doing, and then I'll give it over to my colleagues to talk about themselves. So I think about cryptocurrencies as solving a double spend problem, and it's a really simple problem to solve. It comes up in the Satoshi white paper, and I still think this is what we are solving for. It's a simple thing, but a really big thing. So let's use an example. Say I'm giving you $5. I'm giving you a $5 bill. When I give you a $5 bill, you know I'm not going to spend that somewhere else. And you know that because it's hard to counterfeit that bill. You know what it looks like. Once it's in your hands, you know it's not in my hands, and you feel pretty sure that I'm not going to spend that again. So we've solved for the double spend in all sorts of ways. Physical transaction, what something looks like. So say I'm now sending you money through a Venmo product or a PayPal product. Or even Zelle, right, through a bank. When you get that, and you get that note that now you have $5, do you trust that you have that $5? Well, yeah, you probably do if we're using one of those systems. And that's because we have an intermediary in the middle who it has a ledger, it's debiting my account, it's crediting your account. And you know that because we both trust this intermediary, I cannot double spend that $5. Well, that's great. If you have banking services and other types of intermediaries that you can rely on, you can solve for the double spend. You don't have that kind of issue. If you don't have financial services, hi Mike, if you don't have financial services available, you can still send that $5 electronically, and you know it's not going to be double spent, not because there's someone in the middle. There's no one in the middle. You know I can't double spend because of really interesting, which we're not going to get into, cryptography that means that once I have sent it over to you on the blockchain, it's no longer mine, it's yours. It's a way to share that ledger without someone being in the middle. And with that, maybe someone wants to talk about private versus
and
public
so what
blockchains.
Brinley was describing from my perspective is a public blockchain and an actual use case on a public blockchain, which is why it's one of the reasons why it's got a lot of traction. So put that aside for a second. There's also permissioned private chains. So it's just a distributed ledger that maybe IBM is going to roll out for enterprise customers. So whether it's for logistics management, where they're actually just tracking barcodes. There isn't one on here, but barcodes is an example of tracking something through the system. So you can use a distributed ledger that pushes it out, and then you can track things or otherwise the same way you would use any sort of database, but in a distributed fashion. There's some certain advantages to that and some disadvantages. When it's permissioned in private, it's going to increase speed because you don't have to go through the sort of consensus algorithm mechanism to verify blocks. You can have a more of a centralized control. And then the other primary use case that I am a big fan of are non-fungible tokens. And so everyone is sort of aware of the fungible tokens, Bitcoin and Ether and things like that. But there's other use cases in the token context where you can create individual unique tokens that represent digital assets that are custom. So artwork or crypto kitties or baseball cards, things like that.
And you need to say who you are.
Oh, and I'm Andy Albertson. I'm a corporate partner at Fenwick and sort of run our blockchain groups, represent a lot of the big exchanges, a lot of the native protocols, venture-backed tech companies, anyone in the ecosystem from miners to exchanges.
So when you're having business teams generally coming and thinking about enterprise rollouts, in your experience, it's been primarily looking at some of the distributed ledger, private, permissioned blockchain use cases? And
For what I do, which is primarily representing technology companies that are, and that includes native protocols to Binance and everyone in between, they're using open blockchains, right, or creating their own. There's a variety of reasons for that. The permissioned ones, from a legal perspective, are less interesting, right, because they're not having all of the issues that come up with a public blockchain. But most of the ones that I work with are using the Ethereum blockchain, oftentimes if they're creating tokens, or a lot of the native protocol companies are building a better mousetrap, right? They're in the business of creating a protocol that's going to have different use cases, different features that may be a direct competitor with an existing public blockchain or fill a niche in the market that's not currently being used. But that's a bigger lift than just spinning up an ERC20 or an ERC1404 on Ethereum and using that as your token. Those are different things.
Do people know what that is,
yeah,
though?
so I was going to say, before we go into the sort of like what an ERC20 or like a different, I mean, this directly speaks to governance, and these are sort of governance suggestions, and there's a code name around how the governance of a public open code base works, and we'll go into some of that. However, before we get into public blockchains, because I think a lot of the, maybe as you say, legally interesting and maybe academically interesting and technically interesting work is happening in public or crypto blockchains. Before we get there, I just want to talk a bit more about private blockchains, enterprise, because again, the vast majority of the last panel was talking about smart contracts in their use within frameworks that council may be already more familiar with. And you may describe private blockchains as an incremental approach on top of what is already there, but let's talk a little bit about what that increment is and what is already there that you're incrementing on. Do you want to talk to that?
Yeah, so I'm not a technologist, but I'll give you the Andy Albertson understanding of the technology here. So,
but also from a legal perspective. So
yeah, so the permission chain is it's our chain. Andy Tech Company has a centralized server where previously I wanted data, I would go get it. And that was it. And that was the way the technology stack worked for many, many years. Right? Being very simple, but I'm a simple guy, I'm a lawyer, not a technologist. Go in, get it from a centralized database. In a permissioned private blockchain at its core, you're doing the same type of thing, but that data does not live in a centralized database. It lives distributed throughout the network that you're using. And so you can use examples of Walmart. Where do they have their data? Right? Is it distributed and pushed out through the organization so they can track mangoes, which is a classic example that they used? Or is it sort of living in a server farm in Oregon somewhere? And that's sort of the rudimentary understanding of a permissioned private chain. And then I'll quickly say that the distinction here is the big thing. In a permissioned private chain, it's Andy's chain, right? It's just an internal database that we're using, whether it's blockchain or a centralized server farm. The user interface is going to be largely the same. It's really back-end what's going on under the hood. Now, for a public chain, it's radically different. It's open source technology with anyone in the world building application layer technologies on that public blockchain, which is just different than Microsoft or Amazon or Walmart saying, here's the way we're going to manage our data internally and allow our users to grant access to it.
So our blockchain, that the our can be a collective our. It doesn't need to be one single entity.
Correct.
And so what we heard, again, just referencing the previous panel for those who were there was like a very big use case that was talked about in terms of data transfer. And they didn't want to sort of dig into that, but there's the challenge of permissions, access controls, and the context of data protection and security when it comes to permissions and access controls. Now, these things, when we start talking about data sharing and data transfer and who has the right to specify truth with respect to a shared data set, this can also be very much done and has been done pre-blockchain with shared databases, with consortia agreement, outsourcing arrangements, any mechanism where you have a multi-party stakeholder framework that we're familiar with from various different situations, from financial to construction to you name it. There's multi-party agreements that we as lawyers and in-house counsel have to deal with when we're thinking about who has permission or access to sort of change various things. So that's the governance sort of landscape from a legal perspective we're aware of. And private permissioned blockchains build on that in an incremental way. There's this revolution when we move to public blockchains when it comes to governance of these sorts of issues. But that incremental step, I mean, that piece is also...
I think it can be even more than incremental.
Yeah.
And just as an example, it doesn't, maybe you can disagree on whether or not this is enough of a private blockchain, but I think, and then I'm going to not speak for a while so you both can talk, but I think a really concrete example, you can look at some of the software that Ripple is building for banks. So we're looking at cross-border payments. If you've sent a wire overseas, it can be really, really painful. And it's really, really painful because the systems we use haven't really been changed for 70 years and 46 years. It is correspondent banking, and then there are SWIFT codes. SWIFT codes that sort of follow that payment. And a SWIFT code is, again, 46 years it was created and hasn't really been, okay, they might take issue with it, but it really hasn't been changed much since then. It's a code that you sort of send over to the next bank. They look at code and they send it over to the next bank. And it's actually a really manual process. So that's what we have right now, right? It's many organizations working with each other through contracts and using these SWIFT codes. So Ripple's, one of their products is a way for banks, and this is behind their firewalls, right? It isn't as though the consumer needs to see what's happening, but it's a way to do that reconciliation using these elements of blockchain so that when a payment goes through, you can send information in real time, right, back from the bank to the bank and verify it and send back a verification. And you can have an agreement where you have atomic settlement, where you have settlement finality, where you know that that payment is done. And I say that it's not just incremental because that process can move from days and be very expensive because then you need to, I mean, we could talk about liquidity too, which is also really interesting. That can take days and days to seconds, right? So I don't think that's incremental. I think that that is a step function improvement.
What I would also say about, you talked about groups making decisions. I think the public blockchains are a fundamental change in that in the context, because when you had consortiums initially, everybody knew each other, or at least had an understanding of who everybody was. And it's usually a relatively limited set of people, 20 people, 10 companies, whatever the case may be. With a blockchain that is relying on nodes to essentially make decisions on the transactions, you now have potentially thousands of different people worldwide, and you have no idea who they are.
And this, by the way, is what people mean when they say trustless. It's a remarkably confusing term. But when people say trustless, oh, well, how is a blockchain trustless? This is what people are talking about. It's like, how can you actually have a sort of trustless infrastructure where people can still coordinate?
Yeah, and you're basically trusting the majority. You're trusting that there's enough people out there who have a self-interest in making sure this blockchain is accurate, and they're essentially voting on it, or they're mining it. But the idea is that you have all these people that nobody knows who they are, essentially. There's different degrees of privacy in that. And so they're making the decisions, and they're making the decisions that move sort of the blockchain forward. And I think that is fundamentally different than the way systems used to be set up before.
And so I think what we're seeing is with that, both the step change in a private blockchain circumstance, but also this, in a sense, fundamental innovation around trust, which is the public blockchain's remit. We're seeing new business models around reputation, around contracting, around the way that things can be done together. I think those new business models take a leaf somewhat out of open source ecosystems and the migration towards having to incorporate open source into our various platforms, as we were advising. And this, again, sort of speaks to some of those new business models that are coming through. Now, in terms of the use cases and the business models that are, in a sense, novel, obviously when we have that, we have regulatory sort of interest. And so, Lily, I want to turn it over to you. You've got a very sort of deep background, both from a regulatory perspective and advising on commercial transactions around these sorts of payment issues in particular. But maybe you can speak a little to, again, maybe on the meta sense that this conference more broadly is about, how do you advise when you have a new area of technology? What is the general approach that you should take from a best practice perspective, especially where regulators are somewhat varied in their approaches, let's say?
So, depending on the type of blockchain, there are a whole host and type of industry or application that's being implemented. There are a whole host of regulations that may be relevant to that blockchain application or that use case. And the regulators, at least in the US, but probably more broadly on a global scale, are really focused on each of the areas that are within their purview of the regulation, and there's overlapping regulation. For example, here in the US, whether it's the SEC focused on securities law issues, on various blockchain implementations, token distributions that may be securities offerings, whether or not certain transactions on a blockchain are securities transactions for secondary transfer purposes. But also, more broadly, we discussed one of the examples in the payments space. That's one of the first use cases being used in some of these open source public blockchains is the topic of money transmission laws. FinCEN in the US regulates money transmission and the transmission of convertible virtual currency, and it has been the focus for a lot of blockchain companies, whether or not the assets are securities, which is a big topic here in the US. FinCEN's focus has been on whether or not the assets that are transferred across the blockchain in a token format or otherwise fit within the definition of a convertible virtual currency within their regulations. And this is an issue at the federal level with FinCEN, but also state by state. There are a number of states that have their own definitions of convertible virtual currencies, some that are triggered if there's a transmission of one digital asset to another digital asset, and others that are only triggered if there's one digital asset to a fiat currency, so a US dollar transfer. And each of those regulators have different levels of registration requirements depending on that. And that's just the money transmission laws. Certain states have implemented their own virtual currency regulations in addition to money transmission. And I'm based in New York, and the topic of discussion there over the last several years has been the New York BIT license, which is a virtual currency regulation that is in addition to the state money transmission laws that a company either operating within the state of New York or having customers located within the state of New York need to be thinking about. And so these are just a sample between securities and money transmission laws of some of the regulations that may apply, but there are a whole host of others depending on the industry this technology is being implemented. And just more specifically on the topic of FinCEN, the laws regarding convertible virtual currency have existed for many years. However, just last month on May 9th, FinCEN issued a very detailed 30-page guidance that's supposed to be reiterating the existing law, but really touching upon different applications of blockchain technology, from decentralized applications to ICOs to mining, Bitcoin mining or other mining operations, to convertible virtual currency kiosks, just to name a few examples, and directly the application of the FinCEN regulations to each of those different use cases, among others. So definitely top of mind for those regulators.
Maybe a high level there, and maybe we can just talk more about it, is, one of the reasons why this area is so interesting to practice in is that we do have this new technology, and in many ways, depending on the application and how it's structured, it looks a lot like a security, and maybe it makes sense to regulate it like a security. Other times it does look more like a currency, and our regs they work with how it's being used. But there are other applications where it can be really ill-fitting in any particular framework, and to squeeze it into a framework can really limit some of the utility and innovation that you get out of it. So it's a really interesting place to practice.
Yeah, and I was going to say, I agree with you completely. It's also in some ways been chilled a little bit over the last probably 12 months or so because of the SEC activity. SEC has in some ways acted more by enforcement than by guidance. They're sort of 50-50 now. FinCEN has done the same thing. There's been a little bit more of enforcement lately. And so your companies are finding these guide rails basically in part on, okay, who got tagged, what did they do wrong, and are we doing it the same thing? And so it's hard for a company to operate in that space, startups like yours. And the digital currency, one of the reasons I like the practice so much is that for those of us in private practice, it's not just us doing it, it's many of our partners covering so many different areas of this area, because digital currency, digital assets, the blockchain, et cetera, cover all different aspects of regulatory environments. And so it's very hard for companies to operate. I think it's getting much clearer now, or at least sort of where the guardrails are. But the amount of growth and different divergent paths companies are taking with this technology is really tremendous. And so it becomes very hard to figure out what the guardrails are. And so what we've seen, I think it's kind of changing back a little bit, but what we've seen is a lot of companies go offshore. And they stay offshore because it's faster to get regulated to the extent they get regulated. Malta now, I think, is probably the most common one now, but there's been plenty over the last 3 or 4 years. And so it has led to a lot of offshore activity. Again, I think the money is here, so it's coming back, but it's difficult for startups.
Can I ask if any of you have advised in relation to multinationals where they've been able to somehow ring-fence liability within a subsidiary in a particular jurisdiction?
Go ahead.
Yes, I mean, we use offshore foundations every single day, but we don't do it for the purpose of ring-fencing liability. I think that, so when you look at, let's take the FinCEN example. Before May 9th, there was pretty clear guidance around decentralized currencies. So in a very simple, high-level fashion, if you create a centralized currency, regulated activity, decentralized currency like Bitcoin, where there's, was created not through a sale for fiat or other currency, and it was distributed through mining, and then there's no sort of centralized actor. It's pretty clear under the 2013 FinCEN guidance that that's not a regulated activity from a Money Service Business Bank Secrecy Act perspective.
But isn't the question about which bucket you fall in? And there's so many clients that don't necessarily fit immediately within those buckets, and I think that's the challenge.
Yeah, and so no, it's a good question. But on the question of ring fencing, so when we developed a model involving offshore foundations, it was for the intention of creating decentralized currencies, so ones that did not have an administrator. And the unintended benefits, if you think about it that way, of using those types of entities is you can dissolve them, right? They don't have a ton of assets. They are independent. They're at an arm's length. They keep sort of your Delaware application layer technology company, if that's relevant to your model, at an arm's length. And so, I think there's a lot of risk in sort of hanging your hat on that. You've seen with the active participant language, the SEC has come out that they're collapsing different entities and thinking about them in an integrated fashion, and we sort of predicted that. So a long-winded way of saying, I do think that having separate entities in your structure can provide some ring fencing of exposure, but I wouldn't rely on that. And we use those structures for different purposes, and that's not the primary reason why we do that.
And I think wherever you want to do business, you have to think about the regulations in the U.S. because there's no country that has an extraterritorial reach bigger than I think the U.S. So it's not like you can't get too cute, right? And think, well, you can't get me here. No.
So would you say that the approach with doing new experiments in this space should generally follow what we heard on the data protection panel earlier with respect to follow the principles, the intent, because enforcement action isn't going to be comprehensive. They will look to your intent as much as anything else.
So, yeah, go ahead.
I would say the patterns I've seen, at least with the U.S. regulators, is they put out guidance. That's the first warning to ensure that compliance. Then they start with a few enforcement actions 6 to 12 months after that. And they're not that's not a picture of what anyone would necessarily do if they didn't comply with the law at the time, but they're message cases that further send the message that you should be compliant with the guidance that we previously issued. And then there are a whole host of additional enforcement actions and where further penalties may impact the business operation. So I think it's that watching those trends, and I've seen those in terms of some of the blockchain issuances on the ICO front, then we've seen some of those same trends on the exchanges and secondary trading platforms and so forth. I think those are important to watch for from a compliance perspective.
You mean enforcement actions against exchanges or working with exchanges to support enforcement?
No, against exchanges. So first they were focused on the blockchain companies distributing digital assets or distributing certain services that may be secure. I'm using an example in the security space, but the same thing happened in the FinCEN area as well. But then we're seeing more enforcement actions, and then they go after the intermediary. I guess the exchanges examples, intermediaries that should also be helping the regulators facilitate some of those illegal activities. And so watching those trends are important from a compliance perspective, ensuring you're on the right side, because if you missed all of those trends from a compliance perspective, you're going to be in a much worse situation trying to justify to regulator, why did you just miss the last 12 to 18 months of guidance and enforcement actions we've been putting out there?
So let me jump in on, I think, Grant, one of your questions, and then also yours, about different models that don't fit neatly into different paradigms. And so at a first principle, obviously the regulatory regime was not designed for this. And then your question of, how do we think about compliance? And so what we will do is what we refer to as functional compliance. So oftentimes we're going to say, look, it's not a security, or it's not a money service business that needs to register with FinCEN. And that's our plan A. But we are going to comply with Reg D and file a Form D in the US out of abundance of caution.
Interesting.
We're going to run a concurrent Reg S for our IEO or our primary listing on Hobie.
And this is without conceding that
it's a security.
Right.
And on the FinCEN side, if we say, okay, look, we don't believe that we created a money service business as an administrator, using a very specific term under the Bank Secrecy Act. We don't believe that we have. And we're not going to register, because that's a different level of engagement with the government. And we're not going to be able to track every single holder of all of our tokens, because that's antithetical to our pseudo-anonymous blockchain that we just built. But that said, we're going to comply with every single aspect of the Bank Secrecy Act that we can comply with and achieve our business objectives without chilling technology. So we're going to run AML, we're going to run KYC, we're going to have a compliance officer, we might do voluntary disclosures to law enforcement if we see a suspicious activity. We would do all those things to the maximum extent that we would do without conceding that we should be regulated and without doing anything that's an unnatural act. There's just a registration that would put us on the radar of a regulator when we don't believe that we should be registering, or doing things like changing our business plan in a sort of in a way that functionally changes our blockchain or our other business in a way that would be antithetical to our business objectives. So we refer to that internally as sort of functional compliance. And so at a bare minimum, we're going to do that every single time. And I'd love to get Brinley's perspective on this, but when I've read the stuff that came out about Ripple and the complaint and that kind of thing, it's definitely, right, there was...
You should ask Grant. He was working on it
that was
too.
great. So great. So as someone who was on the outside, it was sort of like, okay, it was you didn't register, and that was sort of, okay, one thing. And then they looked at other aspects of compliance or non-compliance and thought about them in segmented ways. At least that's the way that I sort of read what was publicly available. And so when I've always thought about, okay, if one of the companies that I represent was audited, reviewed, subpoenaed, I think it would maybe not with a smile on their face, but if you got 95% of the way there, I think the ultimate penalty and infraction and that kind of thing is going to look different than if you got 95% of the way there and then argue about the 5% non-compliance that you don't think you were subject to.
That's up. You take it,
Yeah.
Grant.
So let me. By the way, I'm Grant Fondo. I'm a partner at Goodwin Procter. I am the founder of our blockchain and digital currency group. I'm also a former federal prosecutor and advise on a lot of the regulatory issues, particularly when they do get the calls and get in trouble.
And I think you were the outside counsel on the Ripple matter.
I was.
Yeah.
Yes.
So educate us, please.
So-
Me in particular.
So I can only educate you about what's on public. But let me just say this, that I think, and setting aside from Ripple, because I don't want to get into sort of on this, but what you see in any regulatory action, there's a lot of components of it. So I think I agree with you that it makes a lot of sense to do everything you can to get it right. And if you make the decision of registering is we don't need to register, but we're going to do all these other things, I think it's a good plan generally. I would say a lot of it, though, depends on, okay, what do the emails say? Do the emails say it's too expensive to comply, we don't want to comply, but we'll do these other things? It's a very different dynamic than a true belief that you are complying, for example. What's going on? Are you ignoring things? So a lot of it depends on the implementation. So, and I'm sure you guys have seen this, like you map out this great plan, then a year later they come back to you and they've done all these different things because startups and companies just evolve, and the people that you spoke to, the people I spoke to, the Brinleys of the world have gone, and then something else happens. So, so there's a lot of issues that sort of come into play when the regulators look at it. They also look at just, the biggest numbers, where's the money going, and what's going on with it, and what are the representations relating to it, and are the founders making a lot of money out of this? So there's all these different dynamics, but for me, it's always where's the money going, because that always establishes the jurisdiction. Are you sending money back in the U.S.? And that's the concern. And if they see a company that is operating good fiscal constraints, trying to do the right thing, you're absolutely right. Very different than companies that are enriching themselves or buying expensive condos somewhere or houses and things like that.
I'm encouraged, and I'm not going to answer your question, but I'm encouraged that this next wave of development, we're going to have technology that really solves use cases. And I think when we see the benefits of the technology, we're going to see regulation that is better suited to how it's being used. And so, as I think about it, up until now, when you had ICOs and these ways to just raise ridiculous amounts of money so quickly, to do what exactly, right? I think we're still looking for, well, how did that make the world better? This next wave of, I think of it as stable value assets and other kinds of ways to move value, that can actually do some real good in the world. So I talked a little bit about what I'm working on now. 1.7 billion people in the world don't have access to bank accounts. They don't have banking services. Well, this is a technology that can actually be used in, say, rural Liberia, where $20 makes all the difference in whether someone is going to feed their children or not, or have a place to live or not. This technology can make a big impact on the quality of people's lives, and for $20, we're not so concerned with AML, right? We have different considerations. So I'm encouraged that, again, this next wave where we actually see some good from this technology, I think it's going to better inform how we want to regulate. Because I think many of the projects that were in the crosshairs of the SEC and even FinCEN, and putting aside Ripple, I don't put them in that category necessarily, but there are some companies where it's not clear what it was that they were doing, other than they had this way to make a lot of money. And that I think just brings up a lot of suspicion with regulators.
So do you think there's going to be congressional action that will change, or just prosecutorial discretion that's going to...
Token Taxonomy Act. That's what
You think that, okay.
No, I don't know what's going to happen. I think it's going to be slow. But
I would say I'm already seeing the regulators changing their mindset towards this technology. Just from the last year or two in the discussions, just a week and a half ago, one of our clients have had one-on-one discussions with both SEC and CFTC are launching a new product, and they want to proactively speak with the SEC and CFTC about that product. And we approached them at the SEC had a big fintech forum on May 31st in DC, and so we approached them saying, hey, we have this new product, we want to sit down with you and talk to you and about other applications. They're like, oh, you're a company that's doing things the right way. We're not, we should set up a meeting, but we're not too worried because we know you guys are always doing things the right way in terms of compliance perspective. We sit down and learn a little more details. But we're hearing that from both the SEC and CFTC regarding this company. And so they're really opening their mind to talking to companies and I would say not changing the regulation, but understanding the need for compliance within the existing regulation, but being more open to these new innovative products that they wouldn't have otherwise been open to, I would say even a year ago, to these discussions.
Yeah, I would agree. I think that the regulators are very much engaged. I think they're very open. I think the only frustration, and it's understandable from both sides, is that making decisions, issuing these no action letters. There was a no action letter issued by the SEC probably about a month and a half ago, and it was helpful, I guess, in a sense, but it was such the extreme of, yes, of course this is not a security token. We got that. It's the gray area that we want. And it's really hard from a regulator's perspective because whatever they send out is like the holy grail. And as soon as we saw it with Munchie, we saw it everything else. Every time they issue something, entrepreneurs react and say, okay, I don't do that, so I'm good to go. And so what they have to do is be extraordinarily thoughtful. But I do think they are being very thoughtful in the meetings. They're asking really good questions, tough questions. They're being constructive criticism in a sense. So I think it's a very, and I agree, it's like probably the last year, give or take, maybe a year and a half. And it's been a very positive development. I think the frustration, like in Silicon Valley, companies want to do this yesterday, and SEC is more like 6 months, 8 months, 12 months, and we have all these other things we got to think about other than your project. Mm-hmm. And that's where the tension and the difficulty is, and there are honest difficulties on both sides. But I think it's a much better place to be now than it was, 3 years ago.
So let me take a contrary point of view. I see that you guys beat me down. It concerns me as a citizen, right? Not as a lawyer, but as a citizen, that we want our regulators to provide their normative value statement about the worth of our technology or our company or our project, right? As an American, I don't want our government to say, this project we're not going to enforce because they're helping people in Liberia transfer money, where these people are just trying to raise money to go public.
You don't want them to choose winners and losers.
I don't think they should.
Yeah.
And
I don't think they are.
Well, I'm saying that on the point of, on the comment of, there are technologies that are coming out, they're going to do good in the world, and therefore the regulators are going to back off. If we allow that to be the regime, then the contrary must also be true. They say, look, from my perspective as a regulator, I don't think that the following things are moral, or I don't think that's a good technology, and so I'm going to enforce against you. And so I get that we want laudable things to come out, but if you agree to that, say that's good, then you must, to be intellectually fair, agree that the other must be okay too, and I don't. And I see that manifest itself with the Bitcoin ETF.
Saying what is bad.
What is bad? What is bad? It's not your role. Is you apply the Howey test, you apply FinCEN, you apply it, and of course there's judgment. We're human beings. But I don't want to advocate for a world to where they have that sort of ability to control those things. Because even if the tie goes to the runner and the good companies sort of win, that's not America.
Well, it's interesting. I was thinking more in terms of once we have real use cases, we can better see how, say, consumer protection and privacy and all these things will apply. It's less theoretical and more, real. But you raise a different point that I think is really interesting.
That's why we need an act of Congress,
Lillian wants to answer that.
Please.
I think certainly I don't think the regulators can pick winners and losers, but they can regulate what fits within their purview to regulate. And so like the SEC, for example, who's evaluating the Bitcoin ETFs, they are worried about investor protection. That is their mandate. They're not trying to help companies build their projects, good or bad. They're worried about the investors not being harmed. And that's where they're coming from in their lack of approval of Bitcoin ETF, because they don't think the underlying markets can support it. There's a lot of market manipulation. There's a lot of valuation issues. I don't necessarily support the fact that they haven't approved it yet. I think there are ways to fix the problem rather than denying the Bitcoin ETF. Right. But I just wanted to highlight, I think that's where they're coming from and not necessarily picking the winners and losers. But there is guidance they could give to show what fits within the securities laws and what doesn't fit within the securities laws. And what doesn't has to be regulated by the CFTC or other regulators or FinCEN that regulate non-securities. And right now they are of the view everything fits in within their bucket of securities. And that's where the lack of clarity.
And do you agree with the conclusion with respect to the Bitcoin ETF?
That they haven't approved it yet?
No, that they should not, subjectively. As an expert, do you agree that based on market manipulation, concern for investors, thinness of market, that it is not appropriate to approve it? Or do you think that the subjective value statements of the regulators have crept into that decision?
I think there are things that they could do to move the approval process forward. As an example, they need accounting firms to help with evaluation issues. There's a lack of guidance being issued to the accounting firms that they need to audit these. They need to have more regulation and support of a trading marketplace that's regulated also by the SEC that they haven't issued guidance on. So I think there are things that they could do to move that process forward. They don't want to, but I see where they're coming from in terms of the underlying issues currently with their approval.
And I think they're clearly nervous, right? If they approve it and then there's investment and people lose money, who do they point to? Like SEC, who should have protected us. So, I mean, I can see their reluctance. It's unfortunate, but yeah.
How far is this entering into a novel way of actually regulating, given, they're relying to some extent upon self-regulatory organizations to provide some sort of industry best practices, but when we start looking at the technology itself, maybe it provides certain affordances around the kinds of disclosures that can be sort of built in. Is that sort of looking too far?
It's a good question, and one that'll get me really worked up is, look, the 33 Act was written when?
A long time ago.
A long time ago, 1933, right? The internet now, right? There are plenty of rich people that don't know anything, and there are a lot of millennials that are a lot smarter than me. And so from my perspective, when those laws were written where it was not buyer beware, you had snake oil salesmen running around the country, information asymmetry was everywhere. It was rampant in our society. And those laws were passed in that time for that. And we have not even come close to evolving our regulatory and legal regime to come up with what is appropriate for today's society, for today's America, where obviously not everybody's on the internet, but most of the country is on the internet. Most people have reading comprehension that they didn't have in 1933. Higher levels of education, and so I believe that it's overly paternalistic and wrong to close off our private markets to highly educated, smart people because they don't have $1 million in net worth. That's ridiculous.
And so part of the sort of public blockchain ICO craze was this notion of democratization of investment.
And if you look at the ICO craze, to me, if you sort of parachute up and think about what did this say about our society, it says that there is this pent-up demand for people to invest in private companies that currently don't have access because VCs are getting it, private equity is getting it. People that are
not going to be an accredited investor, and you're never going to qualify.
You're never going to qualify, and all those reasons, and they keep the people in our society at a socially economic disadvantage, marginalized through these laws and regulations.
So there was a lot of fraud with the ICOs too.
True.
So it's not like
true. But so point number one is there's clearly demand in the country and abroad for access to these types of things, and it's clear that these companies can raise money, create jobs, and do real cool projects. And so from my perspective, if you came up with the right regulatory regime that allowed average but smart people to invest in private companies, it would be a major tailwind to our economy.
So I'm gonna jump in here because one thing that we touched on was, in the context of governance, security tokens. Security tokens are somewhat of an evolution from a technological perspective of baking in governance into the technology itself. Tell us a little bit about that and how that plays into the ICO world and governance as it bakes into blockchain technology.
So let me sort of define security token real quickly. So on one end of the spectrum, you have our classic consumable tokens, a token that is designed to be used in a network for consumption. And right or wrong, people are going to argue about whether or not that's a security. So that could be a security token if it's a security. On the other end of the spectrum, we have state law, what I refer to as state law securities. So I'm a Delaware company. I'm doing my Series B round of venture capital, and I'm going to allow it to be traded on a blockchain. right? It's a security token, but it's really just Delaware common stock. And then you have everything in between there. And that covers things that might have consumable features on them, but then have a dividend right, or a right to profit, or as the network goes up. Sometimes we do real structured ones where you're going to get certain return thresholds that look like interest and downside protection that look like preferences on a preferred security, things like that. So you have this whole range of things. And so some of this stuff, just going specifically to governance, is if you don't have a state law security, how do you govern this? What are the voting rights? How do you protect this constituency that's investing? And true investment here, this is not a primary consumable product. And so that's something that myself and my colleagues, I'm sure you do as well, spend a lot of time thinking about or designing these models and ecosystems. So it's radically different from a governance perspective of governing a native protocol. How are the constituents and members governing it? This is between Andy Tech Company and the owners of this security. What are my rights and obligations vis-a-vis you? And that's a whole different type of governance that's come out of the blockchain ecosystem.
Well, in a sense, that builds on traditional securities law.
It does.
But the token piece of it specifically means a greater transparency, a greater set of enforcement capabilities. What are those pieces particularly that the technology brings?
The technology, from my perspective, the primary thing that it caused was the ability for near-term liquidity in an organized and systematic way. So one of the other reasons that's kept average people, even if you were accredited, right, and you had access, one of the things that keeps people out of these markets is, hey, I have some money, but I want to put 50 grand to work, but I can't put it to work for 10 years and have a binary outcome. This venture company is either going to be a multi-billion-dollar company or it's going to go out of business, and those are the two outcomes. I'm going to wait 10 years to find out. That's sort of the traditional, even angel investing is what we're talking about here. Now with the blockchain, when we get real efficient ATSs online, which are not quite there yet, but what's going to happen is I have 50 grand to put to work, and I have a 1-year holding period. That's it. After the 144 holding period is up, I can resell it. So if that company goes from A to B, and I got, just conceptually thinking about it as the venture capital life cycle, if I invested at seed or A and I went to B or C and I got a 3x return, I can sell it.
But in this framework, we're still talking about a securities framework.
Yes.
So important to securities, we're talking about all of the disclosures and all the information that needs to come from that company.
Mm-hmm.
That doesn't go away with this structure you're talking about, which is different from a distributed blockchain that has a unit of value that is not a security. Mm-hmm. So you're just talking about a different way of
using the blockchain ecosystem. Yeah. And so the difference is if you have a private company stock, it's illiquid. It just is. There's not an active market for it. You're going to have transfer restrictions, right of first refusal, co-sale agreements, all the things that prevent you from having an active market, a really sort of active market that finds a price. Mm-hmm. With the security token on a blockchain, you can facilitate an active market. And that attracts a different capital class, right? It's not just venture capital, high net worth people who can put money to work for 10 years. It's the Andy Albertsons of the world that maybe want to put 50 grand to work, but I want to exit in 3 years and take 100 grand off the table. And that's going to facilitate that.
And from an SEC perspective, right, as long as you're doing all the disclosures and investors know what they're buying, that should be okay.
It's no different. So one of the things that came up when we were representing Facebook before they went public, it was shares post, second market. Now there's equity Zen, all of those types of things. Those sort of grew up out of a secondary market for Facebook private company stock. And what was going on was, you get a phone call, Fenwick, hey, we got another transfer. Okay, read the ROFR and co-sale agreement. Mm-hmm. Does this firm want to pick up their right or not? It takes a month to process. You ask for a legal opinion. You just can't do it, not in an efficient way. And so now with the blockchain, there's going to be opportunities for early company financing with near-term, not immediate, but near-term liquidity that's organized, that solves the double spend problem. Smart contracts with 1404 coming out, you can have more paradigms on the smart contract to comply with securities laws. For me, I think this is where we're going.
And I think to take a step back and think about that as a pattern, as a pattern language, as it were, that is getting encoded and programmed. And again, when we move into code, it's eminently forkable. You can just basically recreate that. Where lawyers are going to be left with, I've heard, is essentially managing the exceptions. Right, so increasingly you're going to have various different transactions, approaches, security offering frameworks that are templated and designed as patterns. And these are the sort of ISO standards, the NIST standards that are being developed in a very nascent space. Would you agree that this is sort of one of the ways that we're going as lawyering generally? as a result of this?
I mean, they've been talking about the death of lawyers ever since I've been practicing. So I don't have that many more years to go yet, but I'm not too worried about it. There's always novel applications to the law. There's always government. There's always enforcement. There's always new companies that want to start something different. So I think it evolves.
Yeah. I mean, this is less about lawyers being out of a job, more just the way that lawyering is going potentially.
Yeah, I mean, I don't see it. I agree that there are dramatic change. Blockchain and the securitization and I think there are going to be dramatic. I think it's more there's going to be dramatic changes in how people invest and how people build their companies, how people all the different financial products that are out there just for digital currency sort of blow my mind away, right? And all these companies are doing things. And so that's where I think the biggest change is going to be. I do agree there's going to be changes in fundraising. We're seeing it with real estate transactions. It'll touch every aspect of the economy, but I don't think it's going to materially impact what lawyers are doing for the night. We're doing different things, but it's not like we're going to get replaced over the next 5 years or just pressing buttons or dealing with sort of the exceptions. The litigators will deal with the exceptions. So we will deal with shoot. This wasn't supposed to happen. This was not what the smart contract was supposed to do. How do we deal with that? They'll deal with that on the litigation side, but otherwise, I don't think so. But I don't know. What do you guys think?
I mean, as a lawyer, I only want to be working on the exceptions. Who wants to do the other stuff? That's where the fun stuff is. So I do that all day long. There is another part to governance that we didn't touch on. So aside from securities, there's just basic governance of a blockchain. I don't know if we want to talk about that, of just how that functions, or maybe we're out of time. But I think it's worth making the distinction that is something different from what we were talking about that relates to a security token.
Let's do. I mean, can you give us a quick overview of?
Yeah. So if we're talking about a fully public blockchain, how the decisions are made, it could be proof of stake. So it's actually the holders of that asset that will vote on everything from code changes to security. I mean, they can vote on everything. Again, it's not centralized, so it's not a group of developers who will just make the decisions on their own. It has to go up to a vote, which is really interesting. So when we think about regulation, this idea that now you have many different stakeholders that are voting and they all have different interests, and ideally they're situated in a way that they're not going to collude, you have other ways of applying discipline to the system. And I think that's also really interesting. Discipline outside of regulation. So it's just another thing to point out. Now, all of this, the benefit for open source code is it's available. You can look at it. It is available for everyone to see. The problem is, and I think you were touching on this earlier, do we need other parties to help us in this, the development of this new technology? I think the answer is yes, because I might see all of the code, but I might not be able to make sense of it. So I would need a third party to vet that, to give it a seal of approval that yes, this smart contract will work. I think earlier days of the internet where you had the HTTPS and you had those different applications, they weren't applications, but they were companies that would give their seal of approval that this security met standards. I think we're going to need something like that, so that if you're going to use a blockchain and you can't go in and read all of the raw code to get some comfort on how it's going to work, you can at least rely on the opinion of someone.
And specifically, one thing that you touched on in our pre-call was this notion of, for example, game theory as a way of organizing that sort of very much plays into some of the thinking of blockchain governance, which goes beyond obviously enforcement per se. And these notions of mechanism design, designing how these systems work, where people don't necessarily trust each other but can see what each other are doing. There's all of these different parts. It gets very academic and really interesting. So you want parties that are not going to collude. So if you can have a node in North Korea and South Korea, that's pretty good because the chances of them colluding are very, very low. So you think about the health of the overall system, and you look at who are the different parties and what are the interests, and who can vote, and what motivates them to vote. And you're going to get different results. So if you're focused on the long-term health of a blockchain, you want to be thinking all about this in your design. Who's going to control it and for how long, and what are their motivations? And if you get that right, it could be really powerful. If you get that wrong, maybe it doesn't last long. Something else is going to happen. But I think there's some really interesting work right now on how to create that
that type of ecosystem.
And just to add a layer, so Brinley is talking about the underlying blockchain protocol governance, but there's also governance to certain blockchain applications. And the thing that comes to mind is the ability to verify someone's identity. So if you have a user-facing interface and you verified someone's identity, you know who all the participants are, that creates this trustless network. That also creates a governance structure. The thing that comes top of mind is social media platform, where you can verify identity and people can govern content on this platform, knowing who each of the users are. And so there's also this user-facing governance that could be created on the front end.
Very exciting space. We've got 5 minutes. Sorry, I've left so little time, but for questions, if anybody has a Jarwin.
Yes, and so we talked a lot about what should be, right? But I want to refocus on what it is right now. For example, so can we officially declare ICO is gone, it's over? So are there any legal alternative to ICOs? For example, if we limited offering to qualified institutional investors, or we limited to foreigners, would that be okay?
Yeah.
Any comments?
Yeah, I mean, you can do, so the IEO craze that's going on now are predominantly Reg S, right? So meaning an offshore compliant offering.
And the IEO being exchange.
Yeah.
So,
But I think even
Well, that's why, I mean, so I guess I'd answer your question by saying define ICO, right? So, I mean, we're constantly doing combined Reg D, so U.S. offerings, typically 506C, so you can do a general solicitation, raise unlimited amount of money. In exchange for that, you have to verify the accreditation of your investors. Pair that with an offshore offering. You can raise as much as you want. You can partner with Launchpad at Binance or Bittrex or anyone else. And you can raise a lot of money. You're just complying with the securities laws. So I think if the question is the cowboy, we're just going to sell to everyone in the United States and not register and just sort of cross our fingers, I think that's behind us. But these more sort of thoughtful approaches, I think, are still in front of us.
But what we're seeing from the SEC, it's not like they're saying, oh, the IEO seems like a great idea. No, like they're not super thrilled with that as a concept.
Right.
So,
but from my perspective, we're complying with the law, and this is where I get concerned about the normative value statement sort of creeping in. If I do a large global offering for some of my Series D, E, and F traditional venture-backed companies, we're doing a Reg S and a Reg D, no different. Call it a digital asset, exact same legal structure, exact same PPM, filing the Form D, same S, Reg S legends, and now all of a sudden I have to read in the public that the SEC is going to come after us because it's an IEO. That to me is an unacceptable policy decision by our regulators.
yeah, but it's a risk that if you're launching, that you need to be thinking about all of that.
You got to think about all these kind of things.
Yeah.
But I think the answer is, come look because our house is totally clean.
and I also agree that you're going to see, or we are seeing a lot more sort of mainstream companies, enterprises looking at approaches where they can be issuing their own currency of some kind because they have a platform ecosystem that they're looking to develop out, potentially in partnership with a consortium, and they see that this approach to developing outside of the borders of your own enterprise are actually becoming more and more frequent, and they're a different way of engaging with your community, whether employees, customers, suppliers, that whole approach to trying to create the new kinds of value flow are not going away at all.
Yeah, tokenization, right? That's what you mentioned, right? Tokenization.
But you need to have a real use case. So say you're a platform and you're on the brink of running out of money, and then you launch, say, and not that I'm talking about any case in particular, but Kik, like you're on the brink of, losing everything, and then you launch a token because, well, that's the only way you can raise money. Don't be too cute about it. Like the SEC is going to look at your documents and is going to know the real story. So have a real use case. Have a real use case.
Yeah, but I would also add that there was a time where the SEC said no token distribution. Every token distribution is a security. Let's default to that.
That's right.
But then they had come out in April with the SEC's framework with respect to digital assets. And I think the messaging from that framework is you need to go thoughtfully through these factors, determine certain distributions of tokens for certain projects aren't securities in applying that framework, which comes from the Howey test. And I think that leaves the door open for some, not a lot of token distributions in the US that may satisfy those requirements and may not be securities, as Andy had described, and have to go through the Reg D process. So that's, the tides are shifting a little, not a lot, in terms of the US market.
A quick question. Maybe it's not so quick, but to the extent we have time, could the panel maybe know it's a large topic, but any thoughts are very interesting.
So I think off-chain governance, on-chain governance, so just for the rest of the background, there's something of a debate within the more technical side of the blockchain ecosystem community right now as to whether or not there should be any notion of decision-making or governance which is off-chain, i.e. isn't embedded within the code. This is sort of the classic example is the forking of Ethereum from Ethereum Classic. Those who are sort of blockchain maximalists or in favor of purely on-chain governance were saying we shouldn't roll back anything, even though this hacker hacked a bug in the code and was able to hack that away, and therefore we should allow them to keep the money. But there was like a notional off-chain governance majority, including Vitalik himself, who basically said, no, this will be too bad for our overall ecosystem. We're going to take an off-chain decision amongst we, the governors of the Ethereum ecosystem. And again, none of that was particularly well formalized. It was more based upon a sort of a notional wealth of trust in that sort of initial leadership. But that was sort of one of the sort of early instances of off-chain versus on-chain governance and the split between the philosophical framework of what should happen. Now that's come along some way since that happened 2.5, 3 years ago. But essentially there's still a debate over to what extent there should be frameworks for allowing the pure code to have some overriding off-chain governance, i.e. amongst like a human supervisory aspect. And again, somewhat ideological, because a lot of the excitement around public blockchains in particular is that nobody can, from a human perspective, come in and separately be corrupted. It's all in the code and it's all transparent for everybody to see. And from a philosophical aspect, that's kind of somewhat of the how we regulate question, right? From lawyers' perspective, we're overwhelmingly, no, we lawyers, we have human moral values that we try and implement as part of our normative frameworks for society. This is a good thing, and us having checks and balances, like court systems, the way you have real humans judging moral efficacy, is a good thing. From a coder perspective, they're like, humans are corruptible. We should have everything on-chain and in the code and viewable and passable there. But then you end up with potentially the tyranny of machines, AI, and Skynet. So I'd say it's still a very open question. I'd say as more lawyers get involved, as regulators come to see how blockchain is going to influence more and more of the economy, I'd say we're going to see more of a push towards having more off-chain governance roles.
Which I think is problematic. I don't know, my perspective is off-chain governance feels really problematic to me, because that is the beauty of having the code. You know what to expect. I think of it too from a decentralization perspective. So we now know from the SEC, it's pretty clear that your project really needs to be decentralized and not fall into the securities framework. Okay, well, decentralized, but I'm going to have some decisions that are made by a small group of humans. That feels more centralized to me. So I don't. It's interesting.
How about on permission? I actually mentioned Ripple several times. That Ripple is near and dear to my heart as well. For my clients implementing it and participating in RippleNet, and I think that's a good example of off-chain governance. I'm wondering if it's more common to see those sorts of documents that look almost more like operating agreements, things that lawyers are familiar with. Is that what the panel's seeing in maybe the world of permission blockchains?
I'll touch on the permission blockchain. At least some of the permission blockchains being used for digital securities or security tokens. The regulators, specifically the SEC, is more comfortable having off-chain governance of that permission blockchain. That changes could be made if there are regulatory reasons to make those changes. They also at times want to have a duplicative record of that blockchain off-chain in order to allow for any discrepancies to be reconciled, especially when you're dealing with a regulated intermediary that's overseeing that process, or trading as an ATS or a broker-dealer that has certain regulatory obligations that are written in the current law that can't necessarily be built into the permission blockchain or public blockchain as it lives today.
So I guess a couple things I would add. On the security token side, yes, absolutely, because it really is a contractual right that you're tokenizing. On the public blockchain sort of token side, the answer is no, for a couple of reasons. One is which, if you don't have any sort of contractual right against a third-party tech company, assuming that there's a foundation that's your administrator for FinCEN purposes, you may not have a common enterprise. It might be an up-the-hill argument to make, but if there's no sort of, we have to then go fulfill these obligations and pooling of assets, that's a good common enterprise argument there as well. And then the last one is for things that are like an algorithmic stablecoin. If there is on-chain interest-like components where it's just sort of self-replicating and creating its own coin that then, if you stake it or something, you're going to get more in like an interest-like fashion. From my perspective, that looks different from an asymmetry of information and efforts of others prong than if you had some sort of governing Federal Reserve type body that's setting the economic policy and making discretionary trades, either in interest assessments or to stabilize the currency through a reserve. Those are different legal analysis for me if it's on-chain or off-chain. So even that little distinction there can make a big difference.
So like a group like that, on-chain governance is much less likely to be deemed a security.
I think so. Yeah, and it's never been litigated, right? But my opinion, I do think so. Yeah, absolutely. Yeah.
No question.
One final word on that is that in our last blockchain group meeting, which I encourage any of you who are interested in this topic to sign up for, we have like a monthly meeting here at Stanford Law School talking all about this stuff, so please come and join us. But the last meeting, we heard from one of our group members, Oliver Goodenough, about the Vermont blockchain-based LLC, and that seeks to embed more on-chain governance with respect to the management of a legal entity. And so, again, there are movements in that area, even amongst regulators and states, to recognize more on-chain governance as the superior sort of binding set of rules. But with that, please thank our panel.